Hey guys, how are you all doing? So we have now got Blake Lively's opposition brief to Jed Wallace's appeal. This is obviously the Texas case. It was dismissed at the end of last year. Jed Wallace filed an appeal earlier this year. Sorry, Lively has finally, because she's had a couple of extensions, Lively has now finally responded. So it is about, the filing is 65 pages. Of that, the actual substantive information is going to be about 50 pages long. This is not going to be a short video. However, I will look at things. I haven't read this yet at all, just to make that point. So as I'm going through it, I might think, oh, you know, I don't need to read all of that, because we may already know it off by heart. And after 2 years going at this case and all the related cases, I might think, well, we don't need to go over that again, we already know. So I will try to skip over anything I think doesn't need repeating for the 1 millionth time, and try and keep this video as short as possible. But however, I'm going to do my usual going through it. I'll probably critique and get on a soapbox at various points as well, like I often do. But that's part of my charm, what people love. So and I find it works best for me as well, because I do like to, when I have a thought, I feel like I need to say it in the moment, kind of thing, rather than come back at the end after reading dozens of more pages and then say it, try and summarize everything. Sometimes I do that too, but I think in this case I'm likely, because it's a long document as well, I'm likely to make my points as I'm going through. And yeah, I'm going to try and keep it as short as possible, but this could end up going over an hour. Okay, so let's go through this. So they start with a certificate of interested persons. So basically, defendant appellee Blake Lively, and who she's represented by. And then there's plaintiff appellants. There's Jed Wallace Street Relations, and who they are represented. This case is, the appeal is in the Fifth Circuit. Okay. There's a brief statement here as well, just regarding any oral arguments. So, appellee, that's Blake Lively, respectfully submits that oral argument is unnecessary. Of course she does. The district court's dismissal on personal jurisdiction grounds involves straightforward application of well-established law to undisputed facts. The briefs and record adequately present the issues, and all argument will not significantly aid the decisional process. If the court nevertheless sets this case for argument, appellee requests the opportunity to participate. And it's really important to just sort of note, this is an appeal. So, neither party can really bring in new facts or claims. Jed Wallace has to make his appeal specifically on the order dismissing the case. Any sort of issues, basically, any errors in law, so on and so forth. I will put a link in the description. I'm sure if I will try and find it. If I have read his appeal brief in full on a previous video, I will put a link into that in case anyone wants to go back and just refresh their memory. If I haven't, what I can't see that I wouldn't have done that, but if I haven't, then I will do a follow-up video then doing that, just to cover it. And then I might do and what I'll do either way is basically possibly a PowerPoint then to summarize the kind of the competing points between both parties. Okay, so I'll go through all of this, all the citations. Okay, So, statement of issues presented for review. Whether the district court correctly held that it lacks personal jurisdiction over Miss Lively. Whether, if the Wallace party sufficiently alleged personal jurisdiction, affirmance is warranted because venue is improper. Introduction. So, we know most of this, but I will read it. In August 2024, after Blake Lively privately reported sexual harassment connected to the film It Ends With Us, Wayfarer Studios and its executives recruited Wallace and Street Relations to implement a retaliatory social digital mitigation and remediation response. This appeal arises from the Wallace party's tenuous attempt to impose liability on Miss Lively in Texas for exposing their participation in the resulting social media combat plan to bury Miss Lively's reputation. And I mean, she keeps using that word bury. I don't think it was particularly strong anyway, and obviously it was part of the main headline of the New York Times. That word was used in a private conversation between Melissa Nathan and Jen Abel. It is not something that Jed Wallace has ever, really been, linked to. No one said that Jed Wallace could bury her. If my memory serves me correct, yes, they did insinuate Jed Wallace could do a lot of things, but none of this has actually been proven. And it obviously wasn't proven in the New York case either, because he was dismissed from that. But she keeps sort of trying to link him to this word bury, burying Lively and her reputation, etc., etc. But the text messages weren't actually linked to Jed Wallace. So I feel like some of these things it's important to remind ourselves of some of these things and the context. Okay, the district court below was presented with several threshold and merits defects in the first amended complaint, but it dismissed at the outset on the most fundamental one, the absence of personal jurisdiction over Miss Lively, a non-resident of Texas with no meaningful connection to the forum. In reaching that decision, the district court collectively evaluated the Wallace party's asserted basis for personal jurisdiction between Miss Lively and Texas. A Rule 202 petition filed and voluntarily non-suited within 14 days without service. Background references to Mr. Wallace's Texas residence in a complaint filed with a California administrative agency alleging California law violations by California employers, and conclusory information and belief allegations that Miss Lively made unspecified defamatory statements during visits to Texas and correctly concluded that none adds up to sufficient jurisdictional contacts. Unable to show that the district court applied the wrong legal standards or ignored non-conclusory allegations, the Wallace parties centre their appeal on alleged legal error that amounts to nothing more than their dissatisfaction with the well-reasoned outcome. From there, through largely repetitious argument, they fault the district court for declining to treat an unserved discovery vehicle as if it were extensive merits litigation, for recognizing that nationwide publication does not constitute purposeful direction toward Texas, and for declining to credit allegations the district court deemed speculation. None of these arguments identifies reversible error. Instead, affirmance is warranted on multiple independent grounds. First, the district court applied the correct legal standards by accepting all non-conclusory factual allegations, assessing the asserted contacts collectively, and rejecting only those allegations too speculative to carry the Wallace party's jurisdictional burden. Second, the first amended complaint fails to establish minimum contacts because the alleged defamation arises from a California administrative filing relating to conduct that Wallace previously swore was directed at California, not from any Texas-directed conduct. It fails relatedness because neither the Rule 202 petition nor the alleged Texas visits gave rise to the defamation claim. And it fails fairness because there is no constitutional basis to require a New York resident with only incidental Texas contacts, unrelated to the Wallace party's claims, to litigate a California-centered dispute in Texas. See, this is where I disagree with her. It is not a California-centered dispute. Right, so what she's... the hypocrisy here. Now, Wallace is saying, well, you know, Texas law should apply because actually Lively attempted to start litigation in Texas against him with a Rule 202 petition, which is basically a mandatory deposition. It's almost like an interrogation, actually. It's quite an aggressive deposition. She tried to serve him in Texas with Texas process servers, and she could not do that because he was unwell at the time, which, she blasted out to the world. And she's saying, well, that's not enough. The fact that I, signed an affidavit and, an official legal document, so on and so forth, and I tried to serve it all in Texas, means nothing. But yet she's making, on the other side of the coin, she's trying to make the argument, well, I filed a CRD in California, so California law should apply. This is all centered around California. Especially when you think that none of the alleged harassment took place in California. And, the smear campaign technically didn't, the alleged smear campaign technically also wouldn't have taken place in California because the person that's alleged to have been smeared is Lively and she lives in New York. So the hypocrisy is, as usual, very present, very loud in this. And just needed to kind of take a moment to point that out. Okay. Right. Third, even if jurisdiction were proper, the court may independently affirm on grounds evident below that venue is improper in Texas, a forum that lacks any meaningful connection, let alone a substantial one, to the alleged events in this case. Due process and venue rules prevent this situation. An effort to force a non-resident defendant to defend herself in an attenuated forum that the allegations and sworn testimony do not support. This court should affirm. Okay, so statement of the case. Factual background. Lively files CRD complaint. Miss Lively is an actress and entrepreneur. Miss Lively is a D-list actress and failed entrepreneur who resides in New York. She starred in It Ends With Us, which Justin Baldoni directed, at least on paper, and Wayfarer Studios, owned by Baldoni and a billionaire financier. Oh, we have to get the billionaire in. Produced and owns. After Miss Lively reported sexual harassment and misconduct on set by Baldoni and Wayfarer CEO Jamie Heath, a signed contractual rider established 17 protections to help Lively get a PGA letter. 17 protections to ensure a safe set. Including the requirement that Baldoni, Heath, Wayfarer and others not retaliate against Miss Lively for raising concerns or requesting safeguards, and that the non-retaliation provision applied at all times, including during publicity and promotional work. As promotion for the film began in the summer of 2024, Baldoni became concerned that Miss Lively would speak publicly about the on-set harassment and sought assistance from crisis management professionals including Melissa Nathan, TAG, Jennifer Abel and Sarowitz, who promised to spend $100 million to ruin Miss Lively and her family's lives. Ugh, this is so cringy reading all this shit again. TAG first approached Wallace and his company Street, which provides crisis mitigation services to high-profile clients, on August 7th, 2024, about assisting it in social digital mitigation and remediation regarding Wayfarer. The Wallace parties began work on the project on August 9, 2024. Street was incorporated in California in 2008, but converted to a Texas corporation on February 6, 2025, after the Wallace parties filed this lawsuit. On December 20th, 2024, Ms. Lively filed an administrative complaint with the California Civil Rights Department as a necessary administrative prerequisite to initiating a federal lawsuit. The CRD submission included the required intake form and an attachment detailing the misconduct in the form of a civil complaint. The CRD form identified 10 respondents and stated that those respondents engaged in a variety of conduct in violation of California Government Code Section 12940, FIHA, and Title VII of the Civil Rights Act of 1964, including sexual harassment, retaliation, failure to investigate, prevent, and remedy harassment, and aiding and abetting harassment and retaliation, all of which, just to remind everyone, were dismissed on summary judgment. Nearly all of them were. I think it was just the aiding and abetting harassment and retaliation that remained, which Lively voluntarily withdrew when she settled the case. For nothing, for no money. The summary description was prefaced in and or alternative terms, making clear that not all of the summarized conduct was alleged against all respondents, and was followed by the statement, "See attached for specific details." The attached CRD complaint includes specific factual allegations supporting Miss Lively's claims. Its nearly 50-page paragraph factual background detailed the harassment Miss Lively and others faced on set, none of which referenced the Wallace parties in any way, and the remaining 125 paragraphs addressed the retaliatory plan launched after production by Baldoni, Heath, and Wayfarer with the assistance of TAG, Nathan Abel, and the Wallace parties. This included their detailed, coordinated, and untraceable effort to bury Miss Lively, including by leveraging efforts on social media. So, if you look at that one sentence, right, it makes no fucking sense. How can something include a detailed but also untraceable effort? It makes no sense. Because even if these text messages contained detail on how to trace the smear campaign, Lively still never found it. All the discovery in New York, she still never found it. All the 100+ subpoenas to content creators she swore blind were working with Friedman, and she still never found anything. Aside from the Wallace party's inclusion in the caption of the attached CRD complaint, Wallace's name appears in only 7 paragraphs of the document, all relating to the retaliatory campaign, and Street is not mentioned at all. 5 of the 7 paragraphs quote documents reflecting verbatim references by Tag, Nathan, or Abel to Jed in their own correspondence, and the remaining 2 explain background on who Mr. Wallace is. The Wallace parties and others initiate a lawsuit in California. The day after Miss Lively filed the CRD form, on December 21st, 2024, the New York Times published an article reporting on the allegations entitled, "We Can Bury Anyone Inside a Hollywood Smear Machine." 10 days later, the Wallace parties, along with the other individuals and entities identified in the CRD complaint, initiated a lawsuit against the New York Times in California State Court, including based on assertions that the article defamed them by stating that the plaintiffs orchestrated a retaliatory public relations campaign against Lively for speaking out about sexual harassment, and that they waged an affirmative campaign to harm Lively by planting news stories to shape social media discourse. The plaintiffs dismissed the California complaint shortly thereafter, on February 3rd, 2025. That was, she neglects to say, that was to consolidate the case in New York. Ms. Lively commences New York litigation and a related Rule 202 petition. On December 31st, 2024, the same day that the Wallace parties filed suit against the New York Times in California, Ms. Lively initiated action in the United States District Court for the Southern District of New York, with a complaint nearly identical in substance to the attached CRD complaint, asserting federal and California state law claims against the Wayfarer parties, It Ends With Us Movie, LLC, Nathan, Tag, and Abel. On January 16, 2025, all the New York Wayfarer defendants other than Tag filed a separate lawsuit in the Southern District of New York, asserting 7 causes of action, including based on the allegation that the CRD complaint was rife with lies and doctored evidence. On January 31st, 2025, the New York Wayfarer plaintiffs amended their complaint to include the New York Times as a party. On January 21st, 2025, in connection with the SDNY action, Ms. Lively filed a Rule 202 petition in Texas, seeking to obtain discovery from Wallace concerning his alleged role in the retaliatory campaign against her. 14 days later, Ms. Lively non-suited the Rule 202 petition without prejudice for reasons of judicial economy, before Wallace had been served or deposed, but that wasn't for want of trying to serve him. Thereafter, on February 18th, 2025, Ms. Lively named the Wallace parties in the SDNY action. The Wallace parties moved to dismiss the claims against them in the SDNY action and attempted to stay discovery pending resolution of their motion, a request that the New York court quickly rejected, but granted to the New York Times. In moving to dismiss on, inter alia, grounds of personal jurisdiction, the Wallace parties argued that their conduct was not directed at New York. Wallace worked remotely from Texas, and that none of his work was in or directed at New York. And Wallace swore that he considered its impact to only be in California. On November 5th, 2025, the New York court granted the motion and dismissed the Wallace parties for lack of personal jurisdiction. From June 10th through November 5th, 2025, the Wallace parties were active participants in discovery in the SDNY action. Procedural background. The Wallace parties filed this suit on February 4th, 2025, asserting defamation against Ms. Lively, arising from publication of the CRD complaint and seeking declaratory relief and anticipatory adjudication. Ms. Lively filed her first Rule 12 motion to dismiss on April 7th, 2025, after which the Wallace parties filed their first amended complaint. On April 25th, 2025, resulting in the District Court denying Ms. Lively's first motion to dismiss without prejudice. The first amended complaint abandoned the original request for declaratory relief and its request for an anticipatory adjudication, instead asserting a single claim for defamation and defamation per se. The first amended complaint also added new factual allegations, including that the CRD complaint was not publicly available online and that Ms. Lively allegedly gave one newspaper in New York exclusive access to documents underlying its article. The first amended complaint also added allegations concerning Ms. Lively's complaints in the Southern District of New York action. Ms. Lively's Rule 202 petition and its non-suit, Ms. Lively's 2 alleged visits to Texas, and republication of coverage. In particular, the Wallace parties identified 2 occasions in which Ms. Lively visited Texas, one after the lawsuit was filed, alleging on information and belief that she made or allowed identical or similar statements to those made in the attached CRD complaint while there. They alleged that Ms. Lively never admitted that her statements were false when confronted by a Texas resident during a March 2025 appearance in Austin. who said Blake lies, and referenced Justice for Justin. That she made unspecified additional defamatory comments about plaintiffs at a hotel in Waco on the same visit, and that discovery might reveal whether she made any additional defamatory remarks while promoting the film at the June 2024 Book Bonanza event in Texas. No factual record supports these allegations. The First Amended complaint is also added more details about the attached CRD complaint's supposed defects and alleged defamatory meaning, but it removed the Wallace Party's original allegation that the Rule 202 petition was a transparent attempt to chill free speech rights, which would have supported a TCPA motion. Lively filed her second motion to dismiss on May 19, 2025, seeking dismissal of the First Amended complaint for lack of personal jurisdiction under Rule 12b-2, improper venue under Rule 12b-3, and failure to state a claim under Rule 12b-6. As discussed below, the District Court granted Ms. Lively's motion under Rule 12b-2 and dismissed the First Amended complaint without prejudice on November 12, 2025. The District Court's decision. In granting Lively's motion to dismiss, the District Court began with personal jurisdiction. The Court evaluated each of Ms. Lively's alleged Texas contacts, Ms. Lively's Rule 202 petition, the alleged Texas effects of the CRD form under Calder, and the First Amended complaint's information and belief allegations that Ms. Lively made or failed to correct statements while in Texas on 2 occasions. The District Court first determined that the unserved Rule 202 petition did not support that Ms. Lively purposefully availed herself of Texas or engaged in active litigation there. Recognizing that a Rule 202 petition is a request for discovery, not a claim, demand, or cause of action, nor a civil action, the District Court declined to interpret defendant's Rule 202 petition as seeking affirmative relief that subjects her to the state's personal jurisdiction. The District Court also evaluated and rejected the Wallace Party's non-binding cases on this point, as well as the claim that Ms. Lively had submitted herself to Texas jurisdiction by paying filing fees and hiring process servers in the state, finding instead that merely effectuating a petition was insufficient to support minimum contacts. The District Court likewise rejected the Wallace Party's contention that the Rule 202 petition surrendered jurisdictional obligations, observing that Lively did not litigate the merits, but instead non-suited the petition without serving Wallace after only 14 days. The District Court next held that Ms. Lively's CRD complaint did not support personal jurisdiction under Calder. The court concluded that the attached CRD complaint's 2 references to Wallace being based in Texas served merely to supply background biographical information that the Wallace parties did not allege Ms. Lively relied on Texas sources in preparing the CRD complaint, and that the Wallace parties failed to allege that Ms. Lively directed her actions towards Texas knowing the effects would be felt there. The court further found that the CRD complaint focused on events taking place outside of Texas. Last, the District Court rejected the Wallace Party's information and belief allegations regarding Lively's visits to Texas as speculation insufficient to establish personal jurisdiction. The court observed that the Wallace Parties had failed to present affidavits, interrogatories, depositions, oral testimony, or comparable proof supporting jurisdiction, notwithstanding that the dispute had been litigated extensively in another court for nearly a year. Having collectively considered the allegations, the Wallace parties asserted basis for jurisdiction and applicable jurisprudence. The District Court concluded that the Wallace parties failed to establish that Miss Lively is subject to personal jurisdiction in Texas, and granted Lively's motion to dismiss pursuant to Rule 12b-2. The court did not reach Miss Lively's alternative arguments for dismissal based on improper venue or failure to state a claim. The Wallace parties, sorry, I'm losing my voice. The Wallace parties appeal and the SDNY grants Miss Lively's fees and costs under California Civil Code Section 47.1. Which, again, it's important to remember. At the point that Lyman granted the fees and costs, and she doesn't say anything about the treble damages, punitive damages, and everything else that she asked for, which he said no to. At this point that Lyman granted that, Wallace had already been dismissed. He was not a party. That's just... It's not going to have too much bearing here. But just to remind anyone, as we're going through this, like, you know, the missing context that Lively leaves out. The Wallace parties filed their notice of appeal December 12, 2025, and filed appellate's brief on May 15th, 2026. While this appeal was pending, the parties to the SDNY action achieved a court-approved settlement of nothing. The Southern District of New York subsequently issued a decision holding the Wayfarer parties and their agents responsible for Miss Lively's attorney's fees and costs under California Civil Code Section 47.1, which shields individuals who speak out about sexual harassment, assault, or discrimination, including retaliation, from retaliatory defamation lawsuits, when their statements are made in good faith and without malice. Okay, so we're actually making good time. We're nearly halfway through, so I'm quite pleased with that. This is quite a nice, easy to read document. Like, the format, not, you know, Lively's done a good job here. But yeah, it's quite nice, and the page doesn't feel cluttered. It's nicely spaced out. Wallace's document is in an identical format, so I don't think it's something that's specific to Lively. Okay, so summary of argument. The district court correctly dismissed this action for lack of personal jurisdiction, and its decision should be affirmed. The Wallace parties failed to establish that the district court erred in analysing only 3 proffered categories of alleged contacts between Miss Lively and Texas, none of which, individually or collectively, established the purposeful availment or direction required by due process. First, the district court properly credited all non-conclusory factual allegations and evaluated the alleged jurisdictional contacts in the aggregate to conclude that the Wallace party's first amended complaint fails to sufficiently allege personal jurisdiction. The Wallace party's criticisms of the district court's deviation from controlling standards reflect, in actuality, their substantive disagreement with the court's conclusions, which are based on appropriate legal standards after accepting non-conclusory factual allegations. Second, the district court correctly concluded that the Wallace parties failed to allege personal jurisdiction over Miss Lively. As the court concluded, the first amended complaint's allegations failed to demonstrate sufficient minimum contacts. Miss Lively's Rule 202 petition filed and non-suited within 14 days without service was not a proceeding demonstrating personal availment and falls far short of the extensive merits litigation required to establish jurisdiction through litigation conduct. The CRD complaint also does not satisfy the Calder effects test. That complaint was filed with a California administrative agency, alleged violations of California law by California employers, and focused on conduct occurring outside Texas. 2 passing references to Wallace being based in Texas are biographical background and not focal point. The Wallace parties failed to allege that Miss Lively relied on any Texas sources. Wallace's own sworn testimony in the New York litigation confirms that the impact of his work was directed exclusively at California. Nationwide publication of the resulting news coverage does not establish purposeful direction towards Texas. And the Wallace Party's information and belief allegations that Miss Lively made unspecified defamatory remarks during 2 visits to Texas are the kind of conclusory, unsupported assertions that courts in this circuit routinely reject. The alleged Texas visits, one of which occurred after this lawsuit was filed, cannot retroactively create personal jurisdiction that did not exist at the outset of litigation. In any event, those allegations fail to provide detail beyond conclusory speculation. One thing I will say, right, and I do actually agree with that argument from Lively. So, when they talk about the Texas resident, you know, who said Blake Lively lies and shouted justice for Justin, that was Colonel Kurtz. I remember it very well. I spoke to Colonel Kurtz about it. You know, it wasn't that. So Kurtz was just kind of just standing there, holding a sign, doing her thing, and almost like a little protest, right? And it made the news. It went viral. But basically, all Blake Lively, in my opinion, really did was just ignore her, not respond to it, not say anything. I didn't love the attempt to make the argument that, you know, because Lively didn't didn't say that what Colonel Kurtz was saying was false, because she made no response whatsoever. Therefore, she affirmed the statements. That's not how that works. There was no direct conversation between Lively and Colonel Kurtz. Colonel Kurtz was kind of, often amongst a kind of crowd, and Lively was at the arena doing her walk in through the crowds. No, she is not going to go up to, a stranger who's calling her a liar and say, no, you're wrong, this did happen. And that's just, I thought it was a very weak argument. I didn't love it at the time they put it in their first amended complaint. Didn't really think it held any water. But, I understand that Jed Wallace's attorneys needed to make all the arguments they really could to tie Lively to Texas. So yeah, that's my personal view on that. But that is not a new thing. I think I have said it. I think I said it at the time. When I was doing my X threads on the first amended complaint, that I just did not like that argument at all. I thought it was. No, it's not an argument I would make, because I do think it's incredibly weak. And clearly the court thought so too. So. And I hate being made to agree with Lively. Everyone knows this now. But, I've always said I would cover this as honestly as possible. And, where Lively, Reynolds, Sloan, the New York Times actually made a decent argument, I will give them that credit for doing so. I will say that actually that's a good argument. Just as much as I do for Wayfarer. I haven't had as many opportunities to do so for the Lively Party side, but, there have been one or two. Okay, let's continue. Okay, third, even if the Wallace parties could establish minimum contacts, their claims do not arise out of or relate to any Texas contact. The defamation claim is based on the CRD filing in California. And neither the unserved Rule 202 petition nor Miss Lively's alleged visits to Texas give rise to or are connected to that claim. Nor would exercising jurisdiction be fair or reasonable given Miss Lively's non-resident status and the limited interest Texas has in adjudication of this dispute as compared to California, where she is also a non-resident, except... I don't know if you guys all remember this, right? I remember every detail of this. So you remember how hard Lively was trying to tie in Wallace to New York, yeah? I mean, she even put, well, they were speaking, they were texting each other on Eastern time. So, therefore, I can tie him to New York with that and Charles Babcock, beautifully pointed out how broad Eastern time applies, how many, areas of America that applies to. Like, it's not just New York. I will say, though, and she was very much, I'm a New York girl, I'm a New York girl, I'm a New York resident. Even in here, she's saying she's a New York resident. But when she filed her Rule 202 petition, she actually signed saying that she was a California resident. I believe she may have a home in California. So, but she used a California address and stated that she was a California resident under oath in this Rule 202 petition. So just to remind everyone of that, and this is where she is trying to say, well, California applies. But she does flip it quite a bit. Okay. Even if this court were to conclude that the exercise of personal jurisdiction is appropriate here, the court may nevertheless affirm dismissal on grounds apparent from the record below. This case warrants dismissal for improper venue pursuant to Rule 12b-3 because the Wallace party's claim for defamation does not arise from a substantial part of the events or omissions that occurred in this district. The court should reach the same conclusion as the district court and affirm the dismissal below. Okay, standard of review. Which I am going to, because that's just citing a lot of cases. So I want to get into the argument. The Wallace parties have failed to establish that Miss Lively is subject to the district court's jurisdiction. A federal court in Texas may exercise personal jurisdiction over a non-resident defendant only if 1. The Texas long-arm statute extends to the defendant's conduct, and 2. Exercising jurisdiction comports with due process. Because the Texas long-arm statute extends to the limits of federal due process, the inquiry collapses into a single due process analysis. Due process requires that the exercise of jurisdiction be consistent with traditional notions of fair play and substantial justice. General jurisdiction is not satisfied here. This court must therefore determine whether the Wallace parties have established specific jurisdiction by evaluating 1. Whether the defendant has minimum contacts with the forum state, i.e. whether it purposefully directed its activities toward the forum state or purposefully availed itself of the privileges of conducting activities there. 2. Whether the plaintiff's cause of action arises out of or results from the defendant's forum-related contacts. And 3. Whether the exercise of personal jurisdiction is fair and reasonable. As to the first prong, the Wallace parties must show that Miss Lively's ties to the forum were ties that the defendant herself purposely forged. Under Calder, courts may exercise jurisdiction over a defendant who purposely directs tortious conduct toward a forum state and the effects of that conduct connect the defendant to the forum. In other words, jurisdiction is not triggered simply because a plaintiff may feel the effects of a defendant's conduct in the forum state. To satisfy Calder, a plaintiff must show that the forum or the defendant's activities in the forum is the focal point of the defamatory publication and that the defamatory publication relied on sources in the forum state. The district court properly analysed personal jurisdiction pursuant to applicable legal standards. The Wallace parties identify only 3 categories of contacts between Miss Lively and Texas. 1. Her Rule 202 petition, filed and non-suited within 14 days without service. 2. The CRD complaint filed in California with a California state agency. And 3. Generally unspecified statements allegedly made during visits to Texas, pleaded solely on information and belief. The Wallace parties contend that in concluding that none of these contacts, individually or collectively, establishes purposeful availment or purposeful direction of tortuous conduct towards Texas, the district court committed at least 3 interrelated errors. First, they claim the court improperly weighed jurisdictional evidence rather than crediting their Rule 202 petition allegations. Second, they argue that the court evaluated Miss Lively's Texas contacts in isolation rather than in their aggregate. Third, they contend that the court improperly rejected their information and belief allegations which should have been accepted as true. Each argument fails. Okay. The district court properly accepted the Wallace party's factual allegations regarding the Rule 202 petition. The Wallace party's argument that the district court failed to accredit their clearly Texas-directed allegations regarding Miss Lively's short-lived Rule 202 petition fundamentally mischaracterizes the district court's analysis. The district court accepted every factual allegation in the First Amendment complaint, describing them verbatim. Having accepted those facts, the court reached a legal conclusion that a Rule 202 petition, a pre-suit discovery device that is not a claim, demand, or cause of action, does not constitute seeking affirmative relief sufficient to subject Miss Lively to personal jurisdiction. And yeah, that's the bit I forgot to mention. Right, okay. So much like it is possible to issue pre-trial, pre-suit subpoenas, so you can issue in a very limited situations, like discovery, before filing a lawsuit. That is what the Rule 202 is, but it's not just like a subpoena, it's a deposition. So she was seeking a pre-suit deposition of Jed Wallace by filing for a Rule 202 petition. So that's what that is. The court's analysis was extensive, citing, analysing, or distinguishing 10 separate cases, and was directed entirely at the legal significance of the undisputed facts, not the facts themselves. Tellingly, despite asserting that the district court failed to credit certain factual allegations, the Wallace parties cannot even identify which allegations the district court supposedly rejected. Indeed, they concede that they are unable to pinpoint whatever the specific reasons for the district court's decision. Their actual complaint is that the court agreed with Lively that her Rule 202 petition was not an original action and was not otherwise litigated extensively on the merits. That is a challenge to the court's legal conclusion, not its treatment of factual allegations, and it is addressed on the merits. The district court properly evaluated Miss Lively's alleged Texas contacts as a whole. The Wallace parties claim that the district court legally erred simply because it undisputedly never considered the whole of Miss Lively's Texas contacts in their aggregate. Similarly, misrepresents the record. The Wallace parties do not claim the court failed to consider any given category of alleged contacts, nor could they, as the court addressed the Rule 202 petition, the CRD complaint under Calder, and the information and belief allegations in turn. Again, their chief complaint is with the district court's ultimate finding that the Wallace parties' allegations do not amount to minimum contacts. But 0 plus 0 is still 0. The aggregate analysis requirement does not transform jurisdictionally tenuous contacts into legally sufficient ones. Whereas here the district court concluded that each category of contact carries no jurisdictional weight, the Rule 202 petition is not an original action, the CRD complaint's focal point was not Texas, and the information and belief allegations are conclusory. Combining them changes nothing. The Wallace Party's belief that a proper aggregate analysis would have credited a mosaic of interconnected forum-directed conduct reflects a fundamental misunderstanding of the law. An aggregate analysis does not require a court to credit contacts as supporting jurisdiction. It requires only that the court consider them together. The district court did precisely that and still found personal jurisdiction lacking. The district court applied the proper standard in rejecting the Wallace Party's conclusory information and belief allegations. The Wallace Parties argue that the district court erred in rejecting the First Amendment complaint's information and belief allegations concerning Lively's presence in Texas, contending that their allegations were sufficiently detailed and that Miss Lively failed to submit controverting evidence. They are wrong on both accounts. The First Amendment complaint's allegations mirror allegations that courts in this circuit have rejected as conclusory. The Wallace Parties provided no detail about what was allegedly said, instead relying on vague references to Miss Lively's allegations in the attached CRD complaint and insisting that her failure to publicly refute those allegations when allegedly confronted by a stranger who referenced justice for Justin without apparently even referring to the Wallace Parties at all while in Texas is somehow enough. Given this, the district court correctly concluded that the Wallace Party's allegations regarding Miss Lively's visits to Texas were conclusory, observing that they had failed to provide the court with any greater level of detail beyond the speculation that on information and belief, defendant repeated the defamatory remarks while in Texas. The court's conclusion correctly reflects the fundamental proposition that conclusory assertions cannot support a prima facie finding of personal jurisdiction. The Wallace Party's attempt to shift the burden to Miss Lively, claiming she had every opportunity but did not submit a declaration or other evidence controverting the Wallace Party's allegations. But Miss Lively was not required to controvert conclusory jurisdictional allegations. Rather, it was the Wallace Party's burden to establish personal jurisdiction when faced with a motion to dismiss. They could have supported their allegations, though, through affidavits, interrogatories, depositions, oral testimony, or any combination of the recognized methods of discovery. Instead, despite months of active participation in the SDNY, during which they engaged in document production, fact discovery, depositions, and numerous discovery-related filings, the Wallace Parties chose to provide nothing more than bare minimum information and belief assertions. Their attempt to blame the district court for declining to credit those conclusory allegations should be rejected. The district court properly dismissed the claims against Miss Lively for lack of personal jurisdiction. The Wallace Parties maintain that, when analysed under the proper controlling standard, personal jurisdiction is clearly established. They are incorrect. As the district court correctly concluded, the First Amendment complaint fails to establish sufficient minimum contacts to warrant the exercise of personal jurisdiction over Miss Lively in Texas. Moreover, even if the Wallace Parties could establish minimum contacts, which they cannot, their claims do not arise out of or relate to Miss Lively's Texas contacts, and exercising jurisdiction would not be fair or reasonable. The Wallace Parties failed to establish that Miss Lively has sufficient minimum contacts with the forum. The CRD complaint was not directed at Texas. The Wallace Parties argue that the CRD complaint was directed at Texas because it referenced the Wallace Parties as Texas-based, and because Miss Lively allegedly knew her acts of publishing and disseminating the CRD complaint would harm the Wallace Parties in Texas. Under Calder and Fifth Circuit jurisprudence, specific jurisdiction in a defamation action requires that the forum state be the focal point of the publication's subject matter and that the defendant relied on sources located in the forum state. the CRD form fails both prongs. First, Texas is not the focal point of the CRD form. The CRD complaint was filed with the California Administrative Agency, alleging violations of California law, FEHA, and Title VII by California employers. The Wallace parties argue that Ms. Lively made Texas the focal point of her accusations by making two references that the Wallace parties are Texas-based and based in Austin, Texas. But the attached CRD complaints passing references to Wallace being based in Texas are precisely the kind of background biographical information that this circuit has held insufficient under Calder. Likewise, the CRD form accused 10 respondents of California law violations arising from conduct in connection with a film produced by a California-based production company and those respondents' retaliatory acts thereafter. That two of the respondents happened to be based in Texas does not transform the complaint into a Texas-focused publication any more than Fielding's references to the plaintiff's Texas connections made the German publications Texas-focused. The CRD form also was not directed at Texas through its publication or republication. The Wallace parties alleged that after the CRD complaint was filed in California, it was shared with the New York Times, a New York-based newspaper, and republished around the world. But as the district court observed, there is nothing to indicate that the article was targeting Texas readers as distinguished from readers in other states. As courts have regularly found, nationwide publication does not establish purposeful direction toward a jurisdiction. Moreover, Wallace himself swore under oath in the New York litigation that he only considered the impact of his work to be in California and that he thought he was doing business and providing his services to individuals in California. The Wallace parties cannot credibly claim that the CRD complaint was aimed at Texas when their own principal testified that the very conduct described in the CRD complaint was California directed. Evidently at a loss for specific examples of how the central allegations against Miss Lively connect to Texas, the Wallace parties rely on a statement in the dismissed Rule 202 petition that a substantial part of the events giving rise to the claims arose in Texas. But as noted, Mr. Wallace has since disputed that assertion in a sworn affidavit, and more importantly, the petition is not the publication giving rise to the Wallace party claims. Second, the Wallace parties do not allege, nor can they, that Miss Lively relied on any Texas sources in preparing the CRD complaint. This failure is independently fatal. The Wallace parties urge this court to disregard the sources prong because Miss Lively is the very person who claims personal knowledge of the alleged conduct. But this court has never adopted a blanket exception to the source requirement. Instead, it has repeatedly embraced it. To kind of go back here, right? She's saying the petition, right? That Wallace is arguing, well, the Rule 202 petition matters because it was directed at Texas. She has made this point here at the end, the petition is not the publication giving rise to the Wallace party's claims, the claims of defamation. She then in brackets puts here the CRD and draft complaints are the core of the defamation claims. I disagree with that, actually. I disagree with that. For this reason, right? Yes, it was what was in the CRD complaint, right? The allegations. But I don't think that's when Wallace is saying you defamed me, I'm not so convinced personally. I may be wrong, but I'm not so convinced that he's saying, well, it was what you put in the CRD complaint, right? He knows that litigation privilege would apply, right? Charles Babcock knows that, and it did. But also, the CRD complaint would have remained entirely confidential had Lively not put it in the New York Times or anywhere else for that matter. And I think that the real source of the argument is not the California directed CRD, but the New York Times New York directed publication. Now, obviously, the New York Times, it was published on the website, so it went further than New York. But there's an argument to say, well, Lively's a New York resident. The alleged harassment took place, in New Jersey, which is, next door to New York, and the actual defamation come from the way that it was published, the way the CRD was portrayed by the New York Times, a New York publication outlet, by New York, journalists. That's where I think that he would argue and should argue that the harm actually came from the publication of the New York Times far more than the CRD, because had the CRD remained confidential, then the damage to the reputation he's claiming would not have occurred. It was from the publication and the representation, the mischaracterization of it in the New York Times, that the harm really happened to Jed Wallace's reputation, because we all read it. While the Wallace parties rely on the Clemens dissent's reasoning to claim that the source requirement is irrelevant here, that minority opinion reasoning is not controlling. Nor does its logic that the source requirement need not apply to eyewitness testimony apply here. The CRD complaint was not personal testimony and could have, but did not, and was not alleged to, rest on Texas-based sources or research. The Wallace party's other cases also do not stand for the proposition that the sources prong is rendered unnecessary. Instead, those cases reflect instances in which, unlike here, the tortious conduct entered and occurred in the forum state under traditional minimum contacts analysis. Although the Wallace parties attempt to distinguish the application precedent of Fielding, Clemens, and Herman, these cases only emphasize that personal jurisdiction is lacking here. As the Wallace parties explain in Fielding, the references to Texas in the publication giving rise to the alleged defamation were purely background. The same holds true for the CRD complaint here. While the Wallace parties emphasize the activities in Fielding that all occurred in Germany and Switzerland, personal jurisdiction was unsupported there because Texas was not the focal point of the story. So too here, with publication and republication of the CRD complaint in national press. Similarly, in Clemens, the alleged defamatory statements concern non-Texas activities, and in Herman, the statements did not refer to specific actions taken in the forum state. As in Clemens and Herman, the CRD complaint addresses allegations of conduct taken or directed outside Texas, specifically in California or New York. Texas is only mentioned in Ms. Lively's CRD complaint as background, and it is not the locus of the alleged conduct. Alright, we haven't got much more to go actually. Thank you for bearing with. Right. Rule 202 petition filed in connection with the SDNY action does not establish the requisite minimum contacts. The Wallace parties argue that Ms. Lively's Rule 202 petition filed on January 21st, 2025 and non-suited 14 days later without service demonstrates purposeful availment of Texas. The district court properly rejected this argument. A Rule 202 petition is only an investigatory tool and pre-litigation method of obtaining evidence, not an original action. Given this, the district court correctly declined to interpret defendant's Rule 202 petition as seeking affirmative relief that subjects her to the state's personal jurisdiction. The Wallace parties attempt to recharacterize the Rule 202 petition as an exercise of judicial power by emphasizing Ms. Lively's payment of filing fees, hiring of Texas counsel, and use of process servers. But as the district court recognized, these are merely means of effectuating the Rule 202 petition, which the court has already found to be insufficient to subject defendant to the court's personal jurisdiction. Filing fees and process servers do not transform a pre-suit discovery tool into an original action or otherwise support jurisdiction. Ms. Lively also did not litigate the Rule 202 petition at all, much less extensively on the merits. It was pending for only 14 days and was non-suited before Wallace was served. Again, not for trying. Desperately tried. When I say desperate, I don't know. According to Wallace's, I think it was his first amended complaint, or it might have been one of the oppositions to the motion to dismiss, the process servers just sat outside his house and honked the horn. So, but I think they went to his home and attempted to serve him on 7 occasions. So she's making it sound like, well, I didn't even serve you, but she really tried. No hearing occurred and no deposition was taken. This fall far short of the extensive merits litigation required to establish purposeful availment through litigation conduct. The Wallace parties tried to distinguish Payne-Webber and Halliburton on the grounds that those defendants were never initiated proceedings in the forum. But the distinction cuts against them. In both cases, the defendants actually participated in Texas litigation far more extensively than Miss Lively did here, yet still were found not subject to jurisdiction. Miss Lively's filing an immediate non-suit of a pre-suit discovery petition, even without even effectuating service, cannot constitute purposeful availment. I don't love how she keeps misrepresenting what actually happened. The information and belief allegations do not establish requisite minimum contacts. Okay. The Wallace party's remaining basis for personal jurisdiction rests on allegations made solely on information and belief that Miss Lively made unspecified defamatory statements while visiting Texas in 2024 and 2025. The district court properly rejected those allegations as insufficient. First, the First Amendment complaint alleges that, on information and belief while in Austin, Lively made additional defamatory remarks concerning plaintiffs, and that, on information and belief, Lively made additional defamatory comments about plaintiffs, purposely availing herself of the Texas forum. These allegations identify no specific statements, no time, and no content. Which I find a bit rich, coming from Lively, who's like, well, yeah, Steve Sarowitz said this, and then provides no context. As the district court concluded, they are precisely the type of unproffered information and unsubstantiated belief that courts have found clearly insufficient to establish personal jurisdiction. Second, the SXSW silence allegation that Miss Lively never admitted that her statements were false when confronted by a person stating Blake lies and referencing justice for Justin is not a statement at all, or for that matter, a statement even related to Wallace or Street. I agree with that. Silence in the face of a stranger's confrontation is not a publication or republication of defamatory material. And again, it's not like Kurtz went up to her and they were having a one-to-one, exchange. It was, she was shouting from the sidelines, So, I don't like this. I didn't like this argument at the time, and you can see how easily that Lively has just pulled it apart. The Wallace party cite no authority for the proposition that a failure to retract constitutes an independent act of defamation giving rise to personal jurisdiction. Third, these allegations are independently insufficient because personal jurisdiction is determined at the outset of litigation and is not affected by subsequent events. The Wallace party's filed this lawsuit on February 4th, 2025. The bulk of Miss Lively's alleged Texas contacts occurred in March 2025 and thereafter, after this suit was filed. Events post-dating the complaint cannot retroactively create personal jurisdiction. Again, I find that rich, right? Because she filed a lawsuit for the sexual harassment and smear campaign in December 2024, but then started to say, she extended it then, and tried to, make events that, allegations that post-dated her complaint retroactively apply to her lawsuit. She tried to say, well, the smear campaign is still ongoing. We had that whole thing with the website and everything that went with that. That actually post-dated her complaint. The content creators, I'd never said a word about this before she filed her lawsuit, but she subpoenaed me for allegedly working with Friedman and Wayfarer, which I did not, which could only have happened post-date her complaint. So the hypocrisy and irony again, I feel like I'm here, my full-time job now is just to point out Blake Lively's hypocrisy. So the claims did not arise out of Miss Lively's limited contacts with this forum. Even if the Wallace parties could establish minimum contacts, which they cannot, they must also demonstrate that their claims arise out of or relate to those contacts. The District Court did not address this jurisdictional requirement, having already concluded that the first amended complaint failed to sufficiently plead minimum contacts. Nevertheless, the Wallace parties failed to satisfy it. The Wallace parties' defamation claims are based on the privileged CRD complaint filed with the California Administrative Agency. Their other asserted Texas contacts, the Rule 202 petition and Miss Lively's visits to Texas, do not give rise to and are unrelated to their claims. If Lively had never filed the Rule 202 petition, the Wallace parties' defamation claims would be identical. Likewise, the claims would be unchanged regardless of Miss Lively's Texas visits, because the alleged defamation stems from the CRD filing, not from anything said at Book Bonanza, at SXSW, or in Waco. Well, no, she has forgotten the New York Times there. And whilst the New York Times largely reproduced and republished the CRD, it did write its own 4,000-word article, which was based off the CRD. And remember, Megan Twohey said thousands of pages of documents, right? So it did go further than the CRD. The Wallace parties invoke Ford's relate to standard to argue that a but-for causal test is inappropriate. But Ford does not eliminate the requirement of a meaningful connection between the forum contacts and the claims. Instead, it requires an affiliation between the forum and the underlying controversy, principally an activity or an occurrence involving the defendant that takes place within the state's borders. The Wallace parties' defamation claims arise from and relate to a California filing allegedly shared with New York media, not anything that occurred in Texas, and especially not the Rule 202 petition initiated in support of the SDNY action or Miss Lively's two visits to the state for unrelated press or personal reasons. The Wallace party's reference to Wien Air, Alaska provides a strong contrast. In that case, the defendant made in-person visits in which he obtained information that he later used against the plaintiff directly related to the conduct at issue. Here, the Wallace parties have not alleged that Miss Lively gathered information in Texas, nor any specific details about her supposed statements while there, which, as alleged, are too conclusory to be related to the Wallace party's claim. In sum, there is no conclusory alleged activity or occurrence involving Miss Lively that takes place within Texas's borders that is connected to the defamation claim. This failure is fatal. The exercise of personal jurisdiction is not fair or reasonable. Even if the Wallace parties could establish the first two prongs of the specific jurisdiction test, and exercising jurisdiction over Miss Lively would not be fair or reasonable. While the district court did not reach this prong, and the Wallace parties contend that Miss Lively forfeited the issue by not briefing it below, that argument fails. The fairness inquiry is a constitutional requirement, and this court may affirm it on any ground supported by the record. The record supports affirmance on this ground as well. Each of the relevant factors: 1. The burden upon the non-resident defendant. 2. The interest of the forum state. 3. The plaintiff's interest in securing relief. 4. The interstate judicial system's interest in the most efficient resolution of controversies. And 5. The shared interest of several states in furthering fundamental substantive social policies weighs against jurisdiction here. Miss Lively is a New York resident with no ongoing ties to Texas. Forcing her to litigate in Texas when the underlying dispute has been extensively litigated in New York and the operative conduct, i.e. the attached CRD complaint, occurred in California, would impose an unreasonable burden. Moreover, Texas's interest in the dispute is minimal. The CRD complaint concerned California law violations arising from a California-based production, and Wallace himself acknowledged that the impact of his work was directed at California. California, where the complaint was filed, the privileges arose, and the conduct at issue primarily occurred, has the most significant relationship to this controversy. While Texas has a general interest in protecting its residents from tortious injury, that interest is substantially diminished where, as here, the operative conduct occurred entirely outside the state, and the plaintiff's own sworn testimony confirms the California locus of his work. Thus, exercising jurisdiction in Texas would not further any legitimate Texas interest and would instead enable the Wallace parties to forum shop into a jurisdiction with no meaningful connection to their claims. I mean, it's arguable that Lively has done that. She has forum shopped California when there is no connection. She filed CRD in California, fine. You know, she also filed with the EEOC, and that had to be filed in Washington, D.C. But, you know, she lives in New York. The film was filmed in New York. The fact that the production company is based in California, and the people she was accusing were residents of California. To me, in this case, I don't find them that relevant. You know, she litigated herself in New York, and she was only applying the California law because she wanted to abuse this privilege. Again, very important distinction between what happened in New York and what is happening here. I have said this before, but I will say it again for anyone who hasn't heard it. The Section 47.1, right? That applies to Wayfarer's lawsuit against Lively. It does not apply to the Lively lawsuit against Wayfarer, right? It was Wayfarer's complaint that was dismissed. They had a defamation claim, and that, you know, it basically is what led to the fact that Section 47.1 was invoked. There is no way that Section 47.1 could have been linked to Lively's own lawsuit against them in New York. But Wayfarer requested California law to apply. They availed themselves to California law. So that is why, you know, it makes much more sense that Section 47.1 applies. I still don't agree that it should apply to Lively, but nonetheless, they, you know, at least they basically took the risk that Wayfarer took the risk that if their defamation claim was dismissed successfully and Lively prevailed, that Section 47.1 could present an issue. Here, in this case, in Wallace, in Texas, Wallace has never ever said He's never consented to California law applying in this case. That has not happened. The merits of the case have never been ruled on. There's been next to no discovery in this case specifically, and there's been no judgment on the merits either. This is all entirely on personal jurisdiction. But yet Lively is still saying, well, you know, I want California law to apply. She sued Wallace in New York. And he never agreed, unlike Wayfarer, he never agreed that California law applied. I think that's a really important, because he didn't join the Wayfarer complaint. He did not join that. He started his own complaint in Texas. Okay. We are really now close to the end. So sorry this has taken so long, but thank you for listening if you're still here. Okay, the Wallace Party's interests in convenient and effective relief are not uniquely served by a Texas forum. By contrast, they were active participants in the Southern District of New York litigation, engaging in document production, fact discovery, and motion practice, demonstrating their ability to litigate in forums outside Texas. No, he was sued in New York. He didn't want to be there, and the evidence of that is his multiple motions to dismiss, which were both, well, two. I think he filed two. Like, she amended. He filed a motion to dismiss, was dismissed successfully. She amended the complaint, brought him back in, and he filed another motion to dismiss, which again was successful. So, no, I don't think that's fair to say they were active participants and they engaged. I mean, how many motions did he file to, you know, try and prevent discovery or various things being compelled? It was ongoing. Right. I think that's so disingenuous there, demonstrating their ability to litigate in forums outside Texas. He was there against his will. It was basically a hostage situation. He was not, you know, it's not like, well, he was prepared to litigate in New York. He did not. They also demonstrated their readiness to litigate in California by filing suit there against the New York Times based on an article reporting on the CRD. Yeah, okay, I'll give her that. That is fair. Although I think that charge was largely led by Brian Friedman. Last, a Texas forum also does not serve the interstate judicial system's interest in efficient resolution or the shared interest of states in furthering fundamental social policies. Permitting litigation in Texas when parallel suits have been filed and resolved in California and New York. Nothing's been resolved in California, by the way. It was just withdrawn to be moved to New York. Again, disingenuous. Would waste judicial resources and risk inconsistent outcomes. This court may affirm based on the alternative ground that Texas is an improper venue. Dismissal for improper venue is also appropriate pursuant to Rule 12b-3. Although the District Court resolved this case on personal jurisdiction grounds without reaching Miss Lively's alternative arguments, this court may affirm on any ground supported by the record. Texas is an improper venue because the Wallace Party's claim for defamation does not arise from a substantial part of the events or omissions that occurred in this district. The Wallace Party's claim, based on the CRD complaint, arose in California where the alleged defamatory conduct occurred, not from events that occurred in Texas. The Wallace parties cannot rely on a few information and belief statements for purposes of venue because these conclusory allegations violate Rule 8 and fail to state any cognizable claim arising from that conduct, and even if that were not the case, the substantial part of the activities from which the Wallace party's claim arises is the CRD complaint, not unspecified statements that they added to the first amended complaint solely to attempt to manufacture jurisdiction and venue in a state and judicial district that have nothing to do with their claims. Again, I disagree with that. I think the state does have something to do with their claims. That is where Wallace and Street felt the harm. Nor can they satisfy Section 1391B2, excuse me, in this case by claiming a substantial part of the underlying event. Miss Lively sought to investigate in the Rule 202 petition occurred in Texas because their claim for defamation arises from the CRD complaint, not from the filing of the Rule 202 petition. Further, where the Wallace parties conducted their business, i.e. the location where Wallace participated in the retaliatory campaign against Lively, is irrelevant to the venue analysis because actions taken by a plaintiff do not support venue under Section 1391B2. Even if the Wallace parties felt injury in Texas, that would not make it a proper venue. Dismissal is therefore also warranted on venue grounds. Okay, conclusion. The court should affirm the district court's dismissal of the Wallace party's claims against Lively. Respectfully submitted. So Laura Lee Prather, again, if anyone has forgotten or is new or hasn't heard this before, Laura Lee Prather used to be Jed Wallace's attorney. So I've done a video, again I'll put a link to this actually as well. I've done a video. Jed Wallace is not all good, right? In this case I feel incredibly sorry for him. I quite like him, but he has done some stuff that is, if true, is not particularly nice. And there was quite a famous case where he was sued by Bam Margera from Jackass. Well, so was Johnny Knoxville and, various other people and the production company as well. There was a lot of people. Jed Wallace was one of them. And I did a whole video on that, just very briefly going over that case, just to give a bit of background on Jed Wallace. It doesn't make him look good at all. But, it in the effort to be transparent and not just blow smoke up his ass, because right now I feel like he's been, wronged. I did do that video covering that, so I'll put a link to that in the description. But Laura Lee Prather, Haynes and Boone represented Jed Wallace in that case against Bam Margera, and Lively hired his former attorney for this case against him. So much like the story of Brian Friedman has previously represented Travis Flores against Justin Baldoni and Wayfarer, but is now representing Justin Baldoni. The same thing has basically happened to roles have been switched with Jed Wallace and his former attorney in a prior case, now representing Blake Lively, basically in opposition to him. So just a bit of interesting information, I guess. Right, so I'm quite happy with the time. I know it's still an hour and a half, but that gave me a bit of time to talk. I didn't have too much to say, but just correcting some details, adding some missing context, the usual things I have to do here. Lively does make some good points. I'm not going to say she doesn't. She does. I don't know what's going to come next, whether there will be another response, whether there will be a hearing on this of some kind, or a conference, or whether the judge will issue something. So I will keep an eye out, and I will let you guys know as it comes up. Next video is going to be, I am going to get on top of the Steve Sarowitz case against Celeste Smith. So I will try to get to that either tomorrow or Monday. And I hope you guys have a really good weekend. Thank you for listening. Take care.